defense to unlawful arrest. This section will be of benefit not only to those who may initiate a suit for false imprisonment or false arrest, but also for peace officers, as it further outlines what is the extent of their authority. Suits are usually brought about because there is no meeting of the minds in regards to the facts or the law of the case. All right. So another important part about establishing your status, okay, and what law you use and what will be enforced against you. Okay. The common law using the state constitution as an affirmative defense, okay, because you are not a member of the District of Criminals, Washington, D.C., okay? If both parties know the law of arrest and what can and cannot be used as a defense to acts of imprisonment, many lengthy and costly litigations can be avoided. Over the course of the history of arrest, there have been numerous defenses raised against claims of false imprisonment, yet the basic defenses, remember, keep it simple fucking stupid, for this charge is usually limited to showing that the arrest was pursuant to law, that the one arresting had lawful authority to act. Remember, statutes don't grant rise to an arrest. Okay, you are not subject to the legislator or their statutory whims. You are not a statutory civilian. Okay, you're not underneath civil statutory law. Thus, a valid defense of proper justification for false imprisonment would normally be one asserting the legality of the arrest. As Justice Hand stated, the law watches personal liberty with vigilance and jealousy, and whoever imprisons another in this country must do it for lawful causes and in a legal manner. Lawful, not legal, lawful causes, okay? Not legal causes of action, lawful causes. Just because the legislator decides that something is an arrestable offense does not make it an arrestable offense. That's the legal side of things, okay? It must be a lawful cause of action. Most of the erroneous defenses have been due to misconstruing the requirements of a suit for malicious prosecution with those required for false imprisonment. Burden of proof. In false imprisonment suits or in allegations of false arrest, it can be no defense that one who was arrested must prove that the arrest was unlawful in order to prevail in the suit. Due to the high regard placed on liberty, all imprisonments of a person are deemed unlawful until the contrary is shown. In Halsbury Law of England, in speaking on suits of false imprisonment, it says, the plaintiff need not prove that the imprisonment was unlawful or malicious, but establishes a prima facie case if he proves that he was imprisoned by the defendant. The onus then lies on the defendant of proving a justification. Now, when you're on the side of the road and they issue you a ticket, and you want them to issue you a ticket. You want them to at least issue you a ticket or at least issue you a warning, because that evidence is proof of false imprisonment and false arrest. Okay, remember, there is no statute of limitation on time that constitutes a false arrest. If you were led to believe that you could move freely without endangering your life, or you were told to stop by somebody and you had reason to believe that you were in danger if you did move forward, your right of locomotion has been impeded, you've been falsely imprisoned and falsely arrested. Remember, you don't have to be put in four walls with iron bars to constitute an arrest. You don't have to be held in a house to constitute an arrest. Mere oral instructions with the belief that you cannot move forward without putting yourself in danger constitutes false arrest and false imprisonment. The only thing the plaintiff needs to plead and to prove is one of two things. Either one, that the defendant made an arrest or imprisonment, or two, that the defendant affirmatively instigated, encouraged, incited, or caused the arrest or imprisonment. When the plaintiff has shown that he was arrested, imprisoned, or restrained of his liberty by the defendant, the law presumes it to be unlawful. Thus, it has been held that in false imprisonment suits, the defendant, in order to escape liability, must either prove that he did not imprison the plaintiff, or he must justify the imprisonment. Stated another way, the burden is upon the defendant to show that the arrest was by authority of law, not statute, law. In a case where two police officers arrested a man who they believed committed a felony, the jury was instructed that the burden of proof by a fair preponderance of the evidence was upon the plaintiff to show that the arrest and imprisonment were not justified. This instruction was held to be wrong on appeal, where the court stated, "It was long ago said by Lord Mansfield, a gaoler, if he has a prisoner in custody, is prima facie guilty of an imprisonment and therefore must justify." Badkin versus Powell, COWP, period, 476, 478. So, in Holroyd versus Doncaster, 11 Moore, Moore, 440, it was said by Chief Justice Best, where a man deprives another of his liberty, the injured party is entitled to maintain an action for false imprisonment and is for the defendant to justify his proceedings by showing that he had legal authority for doing that which he had done. Where the arrest was done without a warrant, the person arresting would have to justify by showing he acted pursuant to due process of law, by showing that there was a felony or breach of peace committed. Where an officer arrests a person without a warrant, the burden rests upon the officer to plead and prove justification. Otherwise, the arrest is prima facie unlawful. In a case in Iowa, the mayor of the town had instructed the town marshal to arrest a man because it had been reported that he was drunk and had been disturbing the peace. The marshal arrested the man in his home without a warrant. When the man sued the mayor and marshal for false imprisonment, the court instructed the jury that the burden of proof was upon the plaintiff, the man arrested, to prove that he was not found intoxicated when arrested. On appeal, the Supreme Court of Iowa held that the court announced an incorrect rule of evidence on the matter. The Supreme Court, in defining the court rule, stated in 2 Bishop on Criminal Procedures, subsection 368, it is said, in matters of evidence, if the imprisonment is proved, its unlawfulness will be prima facie presumed, but authority may be shown by the defendant in justification. If the marshal had a valid warrant, this would serve as justification for the arrest and as a defense to the charge of false imprisonment. Being he had none and witnessed no breach of the peace, he had no defense against the charge. The rule of burden of proof is the same in a criminal proceeding where any arrest made without a warrant, if challenged by a defendant, is presumptively invalid, and the burden is upon the state to justify it was one not only authorized by statute, but also as one not violative of constitutional provisions. Now, remember, statute only applies to you if you are a Washington, D.C., District of Columbia fucking criminal. Otherwise, you are not bound by the civil statutory law, civil codes, rules, and procedures, okay? You have to be a party to that in order to succumb to it. The invalidity of the arrest will render the search invalid and the evidence obtained inadmissible. This was held in Tinselton versus State, 205 W. 825, Wisconsin, 1925. Good faith and probable cause. The most common defense raised in false imprisonment suits is that the arresting officer acted in good faith or with good intent. This argument of defense is often raised along with the defense that the officer had probable cause. Both of these defenses are often misapplied to the action of false arrest. Such defenses are more applicable to suits involving malicious prosecution or abuse of process rather than false imprisonment. As stated by the Supreme Court in Iowa, false imprisonment causes the unlawful restraint of an individual personal liberty or freedom of locomotion. The good faith of the actor is no justification, nor is the want of probable cause an essential element, as in the case of malicious prosecution. In cases of false imprisonment, the only essential element of the actions are detention and its unlawfulness. Thus, malice and the want of probable cause needed not be shown, or are not necessary to prove cause, not necessary to a proper cause of action for false arrest. Even where the unlawful arrest is claimed to have been for the public good, such a defense will not stop damages. It is well settled law that the want of reasonable or probable cause and the want of malicious malice are elements not entering into the action of false imprisonment insofar as actual damages are concerned. The question of probable cause, in its usual sense, is not involved in the action for false imprisonment. Thus, according to the great weight of the authority, the existence of probable cause is not an element or a defense to an action for false imprisonment. A case of South Dakota developed where a sheriff had, due to a mistaken identity, arrested the wrong person as an embezzler upon a warrant which did not name or describe the person to be arrested. The sheriff alleged good faith and probable cause for arresting the man. The state Supreme Court held that the fact that the sheriff acted in good faith and with probable cause was no defense and may not be taken into account in determining the damages which will compensate the plaintiff. In many cases, officers will try to justify an arrest for a misdemeanor based upon a strong belief that the person arrested is guilty. In such case, the appellate court of Illinois held, in an action for trespass and false imprisonment, probable cause and the absence of malice constitutes no defense. In the first form of the action, belief in the guilt of the party arrested, no matter how strong or how well founded in mind of the officer or person making the arrest, will not justify the deprivation of another of his liberty. And it is unimportant whether the circumstances would lead a reasonable, prudent person to believe that the accused was actually guilty. In some cases, instead of asserting that the officer acted in good faith, the defense is raised that malice must be proven on the part of the arresting officer. This defense is, however, groundless in matters of false imprisonment. In an action for false imprisonment, neither actual malice nor want of probable cause is an essential element necessary to recover of general damages. Whatever the motives of the arresting officer, they do not cause or bring about a change in the legality of an arrest, as was asserted by the Supreme Court of Missouri. A lawful imprisonment does not become unlawful because of malicious motives, nor does an unlawful detention become lawful because actuated by a laudable purpose or founded in good faith. Closely related to the defense of good faith or lack of malice is that an arrest is justified where there is no force or injury done to a person arrested. But, as the United States Court of Appeals stated, this does not justify an arrest. All that is necessary to establish false imprisonment is that an individual be restrained of his liberty under the probable immenseness of force without any legal cause or justification thereof. It is not necessary to show actual force, threat, or injury done to the individual's person, character, or reputation. The lack of malice, the presence of good faith, or the presence of the probable cause do not affect the existence of the wrong when the detention is unlawful. Where a deputy game warden had arrested a man without warrant and incarcerated him in the county jail, the deputy claimed that at the time of the arrest, he had probable cause for believing that the plaintiff was then violating the law by hunting without a license. It was held that there was a false imprisonment involved. As the Supreme Court of Alabama said, in false imprisonments, the essence of the tort is that the plaintiff is forcibly deprived of his liberty, and the good intent of the defendant, or the fact that he had probable cause for believing that an offense was committed and acted in good faith, will not justify or excuse the trespass. In an action against a mayor and a police court judge for alleged false arrest and imprisonment, it was claimed that the defendant acted maliciously with a design to injure the plaintiff. It was held by the Supreme Court of Kansas that based upon the claim of malice, the defendants were not liable for false arrest. The proper remedy would be an action for malicious prosecution. The court also stated, the motive with which a restraint of liberty is accomplished, be it evil or good, is irrelevant to the question of whether or not an unlawful arrest has been established. The existence of actual malice is of consequence only as it may afford the basis for punitive damages. In Grainer versus Squarius, 62 Kansas 321 62 P 1005, the court said, as will be seen, malice and willfulness are not essential elements of false imprisonment, and motives of the defendant, whatever they may have been, are not material to the case. And the Court of Appeals of Maryland had stated in false imprisonment suits, the essence of the tort consists in depriving the plaintiff of the liberty without lawful justification, and the good or evil intentions of the defendant does not excuse or create the tort. 11R.C.L. 791. Any deprivation by one person of the liberty of another without his consent constitutes an imprisonment, and if this is done unlawfully, it is false imprisonment, without regard to whether it is done with or without probable cause. In a case of false imprisonment, the defendant claimed that the petition did not state a cause of action for the reason that it was not alleged that the imprisonment was malicious and without probable cause. The trial court held that these claims were only valid in suits for malicious prosecution, and that there was a marked distinction between malicious prosecution and false imprisonment. The Kentucky Court of Appeals affirmed this position was with various citings. In Starkey's Evid 1112, it was said no proof of malice or want of probable cause is necessary to make a case for false imprisonment. Where the life, liberty, or property of the citizen are at stake, good intentions are never good enough. It has never been stated that the citizen's liberty must not depend upon good faith merely, but upon legal rules governing official actions. It has been held many times that in cases of false imprisonment, the defendant can only avoid liability for false arrest by pleading justification for the arrest. All other arguments must necessarily fail. Ignorance of the law. It is a fundamental maximum of the law that ignorance of the law excuses to violating it. One such maximum is as follows: Ignorance of the facts excuses, ignorance of the law excuses not. Every man must be taken to be cognizant of the law. Otherwise, there is no saying to what extent the excuse of ignorance may not be carried. It has been said that an unlawful detention or imprisonment does not become lawful because done out of ignorance of the law. The Georgia Court of Appeals held that it is no defense that a person perpetrating an illegal arrest or imprisonment is ignorant of the illegality of his acts. Knowingly committing an arrest which is illegal is sufficient to fix liability. False imprisonment is treated as a tort and also as a crime. If the conduct is unlawful, neither good faith nor provocation nor ignorance of the law is a defense to the person committing the wrong. After speaking on the constitutional rights of citizens, the Supreme Court of Minnesota further added, as is the case of illegal arrest, the officer is bound to know these fundamental rights and privileges and must keep within the law at his peril. Ignorance cannot be an excuse for violating the rights of citizens or any constitutional mandates such as due process, especially by those who have taken an oath to uphold that law. They become a hypocrite upon the assertion of such an execution. Guilt of party arrested. An unlawful arrest cannot be justified because the arrested party was actually guilty of the charge for which he was arrested. The person charged with an offense can only be deprived of his liberty by due process of law, and this constitutional safeguard applies to the guilty as well as the innocent. Thus, the guilt of the one arrested has no bearing on the legality of an arrest. As stated in Annotation 25A period L period R period 1519. No one can recover damages for a legal arrest and conviction. Therefore, in cases of malicious prosecution, it becomes necessary to wait the final determination of the action. But the same principle does not apply to an action for false imprisonment, as the form of action is based upon an illegal arrest, and no matter ex post facto can legalize an act which was illegal at the time it was done. Thus, nothing that happens ex post facto after the fact of the arrest can change the legal nature of the original arrest. A prosecution and verdict of guilty does not make an unlawful arrest lawful. In a case of false imprisonment where it was being asserted that the plaintiff was guilty, the Supreme Court of Oklahoma said the guilt of the plaintiff is not material. In the Michigan Law Review, it was stated that an arrest is unlawful even though the arrestee being guilty of a felony if the officer had no reasonable grounds to believe him guilty. Thus, neither the guilt nor innocence of the person arrested has anything to do with the legality of the arrest. It thus has been declared that in an action for false imprisonment, the termination of a prior proceeding in favor of the one deprived of his liberty is not material to his suit. Since termination of the proceedings is not material, the fact that the one deprived of his liberty was actually found guilty is immaterial to the false imprisonment suit. But in a suit of malicious prosecution, there must be a termination in the proceedings in favor of the party deprived of his liberty to prevail. If he is found guilty, he cannot sue for malicious prosecution. A false imprisonment case in New Jersey occurred where a woman was committed to an insane asylum by a business partner and was released a few days later by her husband. The woman sued the partner for false imprisonment, but it was argued that the woman failed to plead or prove that the proceedings leading to her arrest and imprisonment in the insane asylum had terminated. The appeals court said that the argument raised did not apply to this case, as it was an action for false imprisonment and not malicious prosecution. The court held the weight of the authority is against the proposition that in the suit for false imprisonment, the prosecution should terminate before a suit for damages can be instituted. In a suit for false imprisonment, a record of conviction for the same offense for which the arrest was made is inadmissible. An action for false imprisonment is to be based upon the legality of the arrest, not upon the filing of a complaint or the proof of an alleged crime or result of a trial. As California Supreme Court said, the finding of guilt in the subsequent criminal proceeding cannot legalize an arrest unlawful when made. Even where a party has pled guilty, the one making the arrest can still be liable for an illegal arrest. Thus, it has been held that consent to an unlawful arrest will not excuse an officer or person from their acts, as held by the Federal Circuit Court of Appeals. We are of the opinion that the law does not permit the citizen to consent to an unlawful restraint, nor permit such a claim to be made upon the part of the defendant. In Wharton on Criminal Law, Volume 1, subsection 751E, it is said, no man has a right to take away another's liberty, even though with consent, except by process of law. And the reason is that liberty is an unalienable prerogative of which no man can divest himself, and of which any divestiture is null. Immunity. The argument of official immunity would seem to be an obvious and logical argument for an officer in defense of charges of false imprisonment. Government is generally immune from being sued, and peace officers are regarded as a member of the government. Thus, it is often claimed that they are immune from suit. But the immunity doctrine does not extend to anyone in the government who causes a wrong. But an immunity from suits is a high attribute of sovereignty, a prerogative of the state itself, which cannot be availed by public agents when sued for their own tort. Under the doctrine of the official immunity, there have been distinctions made between acts that are discretionary duties, which an officer in performance of is immune, and acts which are ministerial duties for which officers remain liable. An officer's official duty is described as a ministerial when it is absolute, certain, and imperative, involving merely execution of a specific duty arising from fixed and designated facts. An arrest by an officer is a ministerial and not a discretionary act. When we come back, we're going to be talking about the use of warrants in arrests. Thanks for joining me.